Yeah.
6:05.
That's okay.
I'm sorry, but I just wanna make sure.
Okay, so far, let's see, with these fights.
Between meetings.
That's right.
Got everybody that time.
They're furthest away, making these kind of noise, so he said, that's what we know, somebody told me that.
Oh, that time.
They're not gonna close that, I'm just saying, it's not. I think it's Kurt's.
35 seconds.
That's what I believe. You just look at these.
I'd say we and I can next thing.
I had a lot of great
Call a meeting to order. I'd like to welcome everybody to our August meeting. At this time, I'm gonna ask Charlie to give us a prayer.
All right, everyone stand and take hats off, please. Thank you. Let's pray. God, we thank you today. We thank you for all you're gonna do for us tonight, God. We love our little town. We just do the business of it. Your will be done in that, Lord. But most of all, thank you for dying on the cross for us. We love you so much. In your name we pray.
Amen.
I
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
If I fall, it's not because I'm drinking. It's just bad food. Okay. Did everyone receive their minutes? I hear a motion that we approve them as presented.
So moved.
Moved, here a second. Second. Moved and second. Any other discussion? All in favor, say aye.
Aye.
Those disapprove, no. Okay. Anybody have anything to come before the meeting, before we start our agenda? Yeah, I have one item, and it's about, they've asked to close a portion of West Waterson Street, and I'm not exactly sure what the date of that, I think it's a 20-something, but it's because they're having a Baptist church and a Christian church meeting together. Last 2 Sundays ago, it was at the Baptist church. I think it was overcrowded. This one up here, I think you only got about maybe 100, 150. And they want to put a tent out there and go from there. So I thought
It's the 26th.
26. Okay.
26.
I thought I'd bring it to the board. Actually, Bill said I need to bring it to the board.
Want to add that to the agenda?
Yes.
Make a motion, we add that to the agenda.
Second.
Moved and second. Any other discussion? All in favor, say aye.
Aye.
Those disapprove, no. Okay.
God, it'll be a good time.
Yeah, I was there.
Yeah, it was good.
Make a motion, we allow them to close the street before that event.
And just gonna close it about a half because you've got another street they can go out on, people live up there. Okay.
Second.
Moved and second. Any other discussion? All in favor, say aye.
Aye.
Those disapproved, no. Okay. Item 4 is ordinance 724 18-1, this is the water and sewer rate increase. This is third and final reading.
Public hearing.
And, did a public hearing too. Yeah. Anybody here with public hearing, have anything in remarks? Okay.
I make a motion, we approve it on final and third reading.
Second. Moved and second. Any other discussion? All in favor, say aye.
Aye.
Those disapprove, no. Okay.
Is that a
Is that roll call?
Yes.
Yeah. Okay.
Mark?
Yes.
Yes.
Ellie?
Yeah.
Bill? Sonia?
Yes.
Brian? Craig?
And let's see. I've asked about the, this is just, since it's on the water, that, we wanna keep the water meeting the same times that we've been having, 6 o'clock. Okay, before I have our board meeting. All right. Item 5 is buildings and grounds, and this is, we've got, Sandy's gonna retire before, so she recommended we get somebody that she can train, get ready for her. We've added some stuff to her. We're gonna add this building over here, we're gonna add this thing in between. And I think, David Crockett Place.
I don't know about that. We, you know,
I think
that's like something we can.
Right. This is, I think it's, and I think a lot of the time we'll get it away from the park and rec and have a thing of our own. That's just my opinion. What do y'all think?
I think it's probably a good idea to make it its own.
Yeah, cause it entails a lot of different jobs thrown into one. She does a good job, Sandy does.
Oh, yeah.
Cause the park,
She may go back to, you know, hothouse and go on single homes.
That'd be nice.
That's good too.
the park is maintained by the park staff, right? She
Right.
doesn't do, but she does the rest of it, so.
Yes,
It's
that
time to
is.
separate it.
Right.
Yeah, she does all the signs and the 4 squares and just a lot of stuff, just a whole lot of stuff. You'd love to see her anywhere. Does a good job, I think,
I think she
personally.
does too. Nothing but compliments on it. Okay. We, have a motion that we add somebody to this position.
Make a motion.
Moved, I have a second.
Second.
Moved and second. Any other discussion? Better roll call that too.
Mark?
Yes.
Eloise?
Yes.
Bill?
Yes.
Sonda?
Yes.
Brian? And Craig?
Okay. Item 6 is Hawkins County Election Commission. Donna?
I didn't know anybody's behind it, so.
Okay, I want to thank you all for allowing me to speak at today's meeting. As you know, I serve as the administrator for the Hawkins County Election Commission. My name is Donna Sharp. The purpose of my comments is to formally request that the town reimburse the Election Commission for legal expenses incurred as a result of a lawsuit filed by the town against the Election Commission. This is not only the right thing to do, it is required by law. As you know, the town filed a lawsuit against the Election Commission on January 18th, 2018, concerning the commission's decision to consolidate certain voting precincts and designate Hawkins Elementary School as the election day polling place for the newly consolidated precinct. These actions were well within the commission's authority under state law, which was explained to the town on numerous occasions both before and after the lawsuit was filed. The commission has always taken the position that the town may request that it holds standalone municipal elections at the courthouse even after the consolidation. Indeed, on October 17th, 2017, I emailed Mr. Phillips regarding the precinct consolidation. In that email, I stated, knowing that the town of Rogersville may want the BMA standalone elections held at the courthouse instead of the designated polling location for the new Rogersville 5th precinct, the BMA may later request the approval of the election commission to hold that election at the courthouse per TCA 2-3-101A2B. Rather than respond to the October 17th, 2017 email, the town filed suit against the commission on January 18th, 2018. The town ultimately agreed to dismiss its lawsuit in exchange for the commission adopting a resolution which states that the current duly and lawfully appointed members of the Hawkins County Election Commission acknowledge the town of Rogersville's request and state it is the commission's desire to honor, to the extent allowed by state and federal law, the town's request to hold its standalone municipal elections at the courthouse, provided the cost associated with notifying voters of the designation is paid by the town. This resolution was nothing new. It was exactly what had been explained in the email on October 17th, 2017. The town's willingness to finally dismiss its lawsuit in exchange for essentially nothing to which it was not already entitled highlights the unnecessary nature of this litigation. We understand that the town, through its attorney, is incorrectly claiming that the lawsuit relieves the town of its requirement to request municipal elections to be held at the courthouse. This is incorrect. We have requested the State Election Commission weigh in on this issue, and it has confirmed that this is not the case. As far as the attorney fee reimbursement is concerned, state law leaves little room for debate on this issue. Tennessee Code 212-101C1 provides that if the legal proceedings names the county election commissioners as defendants in a lawsuit that involves a municipal election, the municipality concerned shall furnish counsel to represent commissioners. There is no dispute that the town named the election commission as the defendant in the lawsuit, and the lawsuit clearly involved a municipal election. This state law requires the town to reimburse the election commission for those legal fees. My comments at this meeting represent the election commission's last attempt to resolve the attorney fee issue prior to filing a lawsuit. We have attempted to bring this matter to the town's attention, but our requests have been rebuffed. Indeed, I laid out the election commission's position in this regard in a letter to Mayor Sales, City Recorder Hutchins, and Vice Mayor Hartness on June 11th, 2018. Additionally, the Election Commission's counsel advised the town attorney of these legal requirements and the town's obligations in a letter dated July 3rd, 2018. If the Election Commission is forced to file a lawsuit to recover these attorney fees, then it will also be seeking reimbursement for fees incurred in the second lawsuit. This is also provided for under state law, TCA 2-12-101C4. This situation is very similar to a case that arose between the Putnam County Election Commission and Putnam County a few years back. There, the court awarded Putnam County Election Commission attorney fees not only for the original action, but also for those fees related to the subsequent action to recover attorney fees. There can be no debate that the state law requires the town to reimburse the Election Commission for these fees. The Election Commission does not want to have to file suit, and I hope it can be avoided. If these fees are not reimbursed, the town will be on the hook for attorney fees in the subsequent lawsuit. The practical thing to do, the right thing to do, and the legally required thing to do is for this body to vote to reimburse the commission for these fees. The citizens of Rogersville do not need to pay for another lawsuit when it can easily be avoided. Thank you. If y'all have any questions, I'll be glad to answer them.
Bill?
I think everybody here is aware of exactly what happened, and it's not quite as Ms. Sharp has said. We received a letter here, Board of Mayor and Aldermen during Glenn did, dated August 21st, 2017, in which the Election Commission stated that they wanted to combine some precincts and move the voting place to Hawkins County Elementary School. They also stated in that letter pretty plainly, according to Tennessee law, the County Election Commission may, upon request from a municipality, consolidate one or more polling places from one or more precincts within the limits of the municipality. Thus, the Election Commission is requesting placement on the next agenda to present its position on combining the south inside and north inside precincts into one precinct and establishing Hawkins County school as the election day polling location. It was discussed by the Board of Mayor and Aldermen, and I think the Board of Mayor and Aldermen made the decision that we didn't want elections moved out of downtown Rogersville because we're trying to protect our downtown merchants, among other things, more people we can bring downtown. So we had that discussion, and then in November, the Board of Mayor and Aldermen passed a resolution asking the Election Commission not to do that, which was ignored, and they went ahead and did it. I received an email in October stating the Election Commission has voted to use Hawkins Elementary Gymnasium as the polling location for this precinct. Knowing that the town of Rogersville may want the BMA standalone elections held at the courthouse instead of designating polling location for the new Rogersville 5th precinct, the BMA may later request the approval of the Election Commission to hold that election at the courthouse. Not we will do it, not we guarantee that it can be held there, but you may request, and you may also be denied when you make that request. Now the law, I don't think we're the ones that violated the law. The law is pretty clear. This is Tennessee Code Annotated 2-3-101. And it says quite plainly, word for word, the County Election Commission may, upon request from a municipality, consolidate one or more polling places from one or more precincts within the limits of the municipality. Now, I read that to you all back some months ago. We looked at that and we thought, let's try to get that enforced. So we filed a writ of certiorari. We didn't sue anybody. We filed a writ of certiorari, which says bring the record before the court and the court will decide. We reached a compromise with the Election Commission. We didn't dismiss our lawsuit. We reached a compromise, and it's in an order, that they could have the county election out there at the school if they wanted to, but that the city election would remain at the courthouse. That order has been filed and has been final now for more than 2 months. Any issue that could have been raised during the litigation period had to be raised then, or you're known as what is collateral estoppel. You can't raise it now. Come in here after we settle that, put that order down and say we want you to pay our attorney's fees is ludicrous to me, absolutely ludicrous. If anybody's attorney's fees should be paid, it's ours for trying to enforce the law. And we haven't asked for it, Ms. Sharp, but we might. Now that statute that they're talking about, they said that cities have to pay for an election commission's attorneys. It says if they're sued over a municipal election, that's talking about a third-party candidate who sues and says, hey, the municipal election wasn't properly held, or you did something, or something was wrong. Yeah, oh yeah, then you have to. Not when the municipality has to actually file the lawsuit in order to enforce its rights as guaranteed by Tennessee Code Annotated 2-3-101. So I disagree. It is not required by law for us to pay that. Does that sound rational to any person? That we have to file a suit to enforce our rights under the election laws, and then we have to pay the attorney for the other side? I don't think so. But at any rate, that's my position. And I might remind the Election Commission, if they intend to file a suit, the first thing we'll do is file a motion to dismiss for collateral estoppel. If they intend to file a suit, they're going to incur more attorney's fees that they're going to have to pay, not us. So that's our position. I think everybody knew exactly what was going on while this lawsuit was going on.
May I say something, please?
Sure.
Okay. The law that Mr. Phillips quotes, saying the County Election Commission may, upon request from a municipality, consolidate one or more polling places from one or more precincts within the limits of the municipality, is the end sentence of a statute that is talking about standalone elections. In the original writ of certiorari that was filed, they were asking that you all were wanting all elections to be held at the courthouse. And we had consolidated 3 large precincts. There was no way we physically could have elections at the courthouse anymore. Now, if you're going to read a portion of that statute, you need to read the whole thing. It's talking about standalone elections. You never lost your right. before that September the 12th meeting, I met with Mr. Sales, Mr. Phillips, Mr. Hutchins in Mr. Hutchins' office. And Mr. Phillips, you were saying you all don't have the authority to consolidate precincts. I got the coordinator of elections on the phone to talk to you. I don't know what your conversation was that night because it was 5 minutes till 7. I came in here and told the BMA, I don't know what the conversation is. We may not be dealing with this tonight, and we didn't. It was tabled. And I offered to come back at your request in that October 17th email. I even said, if you need me to come before the BMA to explain anything, let me know. You never lost your right. I told Mr. Sales that night in that office, he said, are we gonna not be able to vote at the courthouse? And I said, yes, you can have your standalone elections at the courthouse. You never lost that. You are guaranteed that in the law. We never took that away from you. The talking about we might say no. I can't speak for future election commissions, but we see no reason why you would ever be denied a request to have that standalone election at the courthouse. It's easier on us, that's for sure. There's not enough people really that come out on that Saturday, that first Saturday in June, that you have to open up 2 polling locations like we were. I mean, we still had to open up Hawkins Elementary at that time for Rogersville North End Side. So it would have been easy to have brought everyone back to the courthouse for the standalone election. We don't have to carry machines as far. We don't have to have as many people, officers in place. We can handle the early voting in our office. So the lawsuit was filed over something that it started out, you didn't like the consolidation of the polling precincts. Then when we, in one of your letters, you finally admitted, or maybe in the one of the filings in the court, and I assume y'all all have copies of the court papers that were filed. I didn't make copies of them for you. But you admit that that we do have the right to consolidate precincts. So at the hearing that we had in April, it came down to, well, we just want to be guaranteed that our standalone elections can still be held at the courthouse, and we had no problem with that.
I defy Mrs. Sharp to find the word standalone election in that statute. Let me read you the Hawkins County Election Commission minutes of September the 11th, 2017. The discussion was held on combining some polling precincts. There was quite a bit of discussion about the Rogersville precinct. Teresa Greer made a motion to combine precincts 15, 18, and 19 into one precinct that will vote at either Rogersville Middle School or Hawkins Elementary. Judy Trent seconded the motion, and Teresa Greer asked for a roll call vote. Everybody voted aye except Nancy Point, who voted no. Now, I defy Ms. Sharp to find in there where it says, except we're going to allow Rogersville to hold their elections. Doesn't say that, Ms. Sharp.
That's in a separate
It doesn't
statute.
say that, Ms. Sharp.
That is not
Yeah.
even talking, that would have not even been brought up
These
in that
arguments have
meeting.
all been had before the court. The court decided it. We had entered into a compromise that Rogersville could continue to hold their municipal elections downtown. There's nothing in your minutes, and you can't produce anything that says that you were going to allow that beforehand. You said we might request it. You may come and request it. All you said. There's an order now from the court that says they will be held there. And that was the whole purpose of it.
The order, Mr. Phillips, says the current.
Ms. Sharp, I'm not going to argue the law, which I've been before the court. The Board of Mayor and Aldermen has now heard what the issues are.
We have heard Bill and we've heard you. Basically, you've got the court order says that that each pay their own, am I
The
correct?
court order says that
No.
everybody
Discretionary.
Everybody
costs.
pays their own discretionary costs. If in fact they had wanted to request, if they had said, hey, we want you to pay our attorney's fees, I wouldn't have agreed to a compromise. We'd gone through, let the court make the decision and let the chips fall where they may, because I'm about 99% confident we would have won the issue of having municipal elections in the town of Rogersville, which they agreed to. So that's not the case.
Okay.
But it is collateral estoppel. If they wanted to raise that, they should have raised that when the lawsuit was going on. It is now final, non-appealable, They're collaterally stopped from bringing up any other issues.
Anybody else, Mark?
No.
It appears we got something that we really already had. Is that a correct statement?
That is
About-
an incorrect statement. The
That is a
statute,
correct statement.
the statute says the election commission may, upon request from a municipality, consolidate one.
But we had that before we went to court.
Right, but we never requested it.
But
they
we had
went-
it before we went to court,
Yes,
correct?
but they went ahead and changed it. There's nothing in their minutes that says, oh, we're gonna allow Rogersville to continue to have elections. They didn't say
We
that.
wait for you to request it.
It doesn't say we have to request, it says we have to request for it not to be there, not that we have to request for it to be there.
And you said it doesn't say anything about a standalone election. It says when a municipal election is not
I
held
said-
in conjunction with an election specified in subdivision A2A.
That's correct.
that's a
Basically, Donna, what
standalone
you're asking
election.
for is for this board to pay for your attorney, is that correct?
To pay Hawkins County, who was out a lot of money defending this
I understand
lawsuit that
that.
never should have happened.
It's happened or whatever, but you're asking for this board to pay, am I correct?
Yes.
I'm
No.
asking,
What is the balance right now on the last bill you got?
As of right now, it's $14,723. And we could have used the county attorney in this at a substantially less amount, but there was a conflict of interest.
Well, you've got attorneys from Knoxville, which is probably why it cost you $14,000 some odd dollars. I'm sure there are plenty of competent attorneys in Hawkins County that could have handled that for you at a lot less expensive rate.
basically, we need to know, Bill's got a court order, or thing that says that we pay each other, right?
It says everybody pays their own discretionary costs.
Discretionary, which
What's that,
this,
right?
discretionary costs were not involved in this. That's like for
That's,
interpreters, court recorders, et cetera. That does not mean attorney fees.
I'm gonna go on what our attorney says, that's my opinion. I don't know what this, I'm gonna ask that board here what's their opinion on it. But we pay him to tell us what we're supposed to do, and he is, tell us what.
and Mr. Mayor, I agree the lawsuit could have been avoided. All they would have had to say is, we agree to allow you to have municipal elections in Rogersville. And when we filed the thing, we didn't want them to move any elections out. And when we got into it, it became somewhat, well, there was still an issue because of that statute, whether they could consolidate it, move it out, even on the county elections or the state election. But nevertheless, as a compromise, we said, okay, you keep the municipal elections in downtown Rogersville, we'll be fine with that.
One thing I do need to clarify again, and it was in my statement, was that Mr. Phillips seems to be under the impression that y'all will never have to request to have your standalone election at the courthouse again. The law says you do. It's the current election commission agreed to honor your request. They cannot speak for future election commissions.
No, but the statute speaks for itself.
The statute does.
The county election commission may, upon request from a municipality,
Exactly.
consolidate one or more. We didn't ask for you to do that. You went ahead and did it without
Read the
asking.
first part of the statute, Mr. Phillips. You can't,
I'm
you
sorry,
can't
I'm sorry,
pick it
Ms. Jones.
out.
It says what it says.
Okay.
It does.
Why did this turn into a county-wide election precinct? I thought it was for the city election only,
That's what it turned out to be, city election only.
but it was intended to be all the precincts.
When we
of
first
county.
filed it, we wanted to try to prevent elections from being held somewhere else other than downtown Rogersville. When we got into it, looked at the law, we compromised. I came to you all and said, here's what the compromise is. They'll agree to allow us to continue to have municipal elections downtown. They can have the county and state elections out at the Hawkins Elementary School. And the board of mayor and aldermen, then an attorney-client meeting said, okay, we agreed to that compromise. I'm sure you all remember that.
At one time, I know we asked for an attorney general's opinion. Did we ever get one?
They won't give a municipality attorney general's opinion.
Well, I'm not concerned on the county election. I'm concerned with city elections being to courthouse, we've got that, we've had it all along.
No,
I don't-
no, ma'am, we didn't have it all along.
It's your request.
We sure did. We don't have to request. You have to request for us not to be there. We don't have to go to you to request.
But that's irregardless.
This
My thing
has
is-
already been heard by the
Right.
court. I don't know why we're arguing this here.
Well, all I want to find out is the board, you know, she's asking for $14,000 and this board needs to say yes or no.
Mr. Sayers.
Yes.
I'm Judy Trent, I'm a member of the Hawkins County Election Commission, and I sit here and I swear, I just really can't sit without speaking. Donna's did a great job, but I was at that first meeting when Mr. Phillips was there, and I live in Hawkins County. Was raised at Kepler, so Rogersville is my hometown. Whether I live in the country or whether I live in the city, Rogersville is my hometown. And, you know, I'm sure my grandfather came from Kepler and came over here and voted at one time in life. But our sole purpose, when we combined those 3 precincts, was to save money. Because everybody knows the county needs money, the city needs money, we all need money. That was our sole purpose. We didn't take early voting away from the courthouse. Early voting is still there. It's that one day. And, you know, when we were trying to come up with where to vote at, because you can only move a certain distance from the original polling place, I said, well, Hawkins Elementary is on Main Street. It's Main Street. You know, we could have did Rogersville Middle School, but it was up on the hill. That was Rogersville High School when I went there, but it was still downtown Rogersville to me, you know. Hawkins Elementary, I taught a year of school there. That's still downtown Rogersville to me. So if I'm going to eat, it's, you know, somewhere here in town when I'm out on election day. But our sole purpose was never to take away anything from the city, from the county, from the anything. It was to save money. And I know that I said almost these same words to Mr. Phillips that day, that I didn't want to take anything away. And it really kind of embarrassed me that we had this thing going on between us. Because like I said, I live in the county, but Rogersville is my hometown. Ralph is from Churchill. That's his hometown. Teresa's from Sigornsville. That's her hometown. But this is my hometown. And I would never take away from the city. I would always vote no. But our sole purpose, and we've all read this law. We've read it. And when Donna says the whole law is not being read to you all, she's telling you the truth. You need to read the exact whole law, not just a portion of it. But believe you me, nobody on this commission would ever harm anybody in any way. And we really appreciate that you would think that part about us. We're all live in the county. You all may live in the city, but we all live in the county. And our goal, strictly, was to save money. Well, we've not saved anything, because lawyers had to be hired in. And the only reason that we didn't use the other Mr. Phillips were they were brothers. We can't help that either. So we were looking to, exactly, we can't help that, you know. People think Ralph and I are married just because we have the last name of Trent, but we're not. So, you know, things happen, but I hope that you will hear what I'm saying, and that I truly want you all to understand that this could have never happened. That day, we said it all along. You still have standalone elections there. That first day, that was said, you still have standalone elections. It's only that election day. So it was made clear. So I'm sorry it all happened.
Well, I am too.
Yeah.
But, you know, I'm a citizen of Rogersville, but I'm also a citizen of Hawkins County.
Right, you're gonna pay
I
double
pay taxes,
here.
I do pay taxes at both places. You know, it affects me either way. But irregardless, you know, as you're all as a board, you do like we are. We do and pass whatever we do. But what we're here for now is to ask, do we pay for that attorney fee or do we not?
Okay.
Pretty simple, right?
Can we not agree on this without further lawsuits? Because that's just more money.
Well, there has been a suggestion by, and actually I talked both to counsel for the election commission and the election commission also comes in and argues, which is a bit unusual to say the least in a lawsuit. The counsel for the election commission has suggested that we mediate the issue and see if we can arrive at an agreement. It's your decision. If you want to pay their attorney's fees, fine. All I'm telling you is, I disagree. The facts are not as related to you by the election commission. The facts are right here in the minutes of the election.
I don't wanna pay the 14,000, but
Well,
I
obviously.
don't want more either,
Well, I'm sure they don't either.
because I pay county taxes and city taxes. So
What
it's
we're
coming
saying
out of
is-
ours, one way or the
What
other.
we're saying is that we've already paid the bill.
I know
Yeah,
that, I
now
know
we will be
that,
paying
but
that one and that one.
if this was
I'm real
instigated
sure
by
we need to be paying
us,
too.
And I have no issue, and I don't know why Ms. Sharp doesn't know that her counsel has asked for mediation.
I do know,
Well, then why would you be here tonight doing this?
because you never answered his letter where he asked you if you would
Because I have to go,
consider
Ms.
it.
Sharp, unlike you, I have to come before the board of mayor and aldermen and ask them permission. I don't make the decisions, they do. So, and that's what the meeting,
Well,
if
you
you'll
don't-
notice, the last item on the agenda is attorney-client meeting, and that's what that was about, is whether or not you wanted to submit it to mediation. My position is, we did what we had to in order to enforce our rights. I kept everybody here fully informed of what was going on. I told you what the compromise was. And you cannot find in one document where they said you have the absolute right to have a city election in the courthouse until that order went down signed by Chancellor Jenkins that says we have the right to have a city election at the courthouse. So that's the position. If you want to enter into mediation, and I would encourage, if you do, I would encourage as many of you as you can to be there, fine, we'll do that.
I'd be there.
But this obviates the necessity for an attorney-client meeting since it's already been brought out in public anyway.
Load that one, Bill.
Because I just feel like at this point, we're gonna have to have more lawsuits. Plus, we're gonna probably end up paying the 14,000.
I disagree with that, but.
Well, it goes to court to see.
Well, it does, but I don't think that statute applies to when a municipality has to sue or ask for a writ of certiorari against an election commission to enforce their rights by statute. I just don't believe it applies in that case.
I have to listen to you.
Just a hit and miss either way.
That's why I say, if you want to.
Yes, ma'am.
Excuse me, I'm Teresa Greer, I'm on the election commission, and, every municipality has, every time they have an election, whether it's a standalone election or whether it is in conjunction with, state or federal election, however it happens to fall, they have to request to have an election. And at no time did this ever come up. We have no reason to tell a lie about it. At no time did this ever come up. We would like our standalone election at the courthouse. All it had to do was be requested and we would have said yes. What did disturb me was, when this first order was filed that mentioned retail sales. We're not in the business of retail sales. And you have, now that truly is in the first thing we received. And the city has all this early voting time to have people from all over the county visit the town. That's all I have to say.
All right.
Not to belabor the point, Your Honor, but the minutes speak for themselves, and it says that they're combining the precincts and that they're gonna vote at Hawkins Elementary. Makes no exception.
what we
I mean,
didn't
my
say.
contention is, Bill, that's already done and over with.
It is already
My
done.
thing
I
is,
agree.
you know, we paid you, and I don't think we ought to be paying both of them. That's just my contention.
Call for question. There wasn't a motion.
All right, yeah. There's not a motion to.
Can't call for questions if there's no motion.
Okay.
Call for
But anyway,
motion. Bill, can you, and I know you've explained this, but I just want to get it straight in my mind, where TCA 212-101C4 provides that in order to properly discharge its duties, the county election commission has to, the county election commission has to bring legal action against the county or municipality. The compensation for the commission's legal representation shall be borne by the county or municipality as the case may be. And, you know, it doesn't sound right. But is there something before or after that particular paragraph?
You'd have to look at the legislative intent about that, and what they're talking about is when somebody, let's say somebody's running for election, or somebody didn't get to register to vote for an election, and they wanna sue over that, and they sue the election commission, and it has to do with a municipal election, then yes, we represent them in that instance. But when we're the ones actually having to file in order to enforce our rights under a state law, my position is, we certainly don't have to pay for somebody we had to sue.
It's one of those things where there's more before that and more after that.
Oh, yeah, there's a bunch, yeah.
Well, and with us having an order of a compromise and dismissal for both attorneys to assign, does that mean both of were agreeing to set before us?
That's exactly what it means, and it's a final order. You have 30 days to appeal it, and that's 30 days is long since passed. If you bring anything else up that could have been brought up during the pending of the litigation, it's called collateral stop, and you can't bring it up.
So in other words, that's, to me, it's done deal.
Yeah.
Sounds like cut and dry,
Yeah.
don't need anything else added to it.
Okay.
But I still think we will be facing more expense that the county or the city does not need.
Well, it's like I say, if y'all wanna mediate it, that's fine. I mean, that's up to you, but I just want everybody to be sure they know the facts. And I try to keep you informed with attorney-client meetings on at least 2 occasions, I know.
With this, I don't see what we need to do.
Well, I do,
According to this.
because it's not by long shot, that,
According to that right there, it is.
well,
All right, boys, what do you wanna do?
I mean, what's done is done, and our city attorney is advising us that we should not, that it's all done. I know he knows how to read the law. I make a motion that we don't pay.
All right, we have a second.
I'll second that.
Moved and second. Any other discussion? All right. I think we'll need roll call.
Mark?
Gonna have to abstain.
No, Lee?
no.
Lee?
Yeah, I'm voting for it.
Not to pay, right?
Not to.
Not to pay.
Not to pay. Vote not to pay.
I vote to pay. Be done with it.
What was the vote?
You got 3 not to pay, you got 2 to pay,
One not to pay.
and 1 abstain.
Yeah, 2 not to pay, 3.
I voted not.
That's 2, that's right.
Not to pay, not to pay. 2 pay, 2 pay, 2 pay.
No.
Totally opposite what you said. Y'all's got me confused.
confused me now.
Not to pay, not to
pay, not to pay, not to pay.
Pay,
Pay and pay. Right? That's what I had.
okay.
And abstain. Right?
You changed my vote.
No?
Okay, what'd you say first time? You said no, and then.
Are you voting to pay or not to pay?
No,
Not to pay.
Not.
yeah.
Okay, then it's 4-1. Sorry. See the way they,
It's a double negative.
Yeah, it's hard to figure out what.
and we should have said, we just started that. So we got yes, in pay, yes, not to pay.
I don't wanna pay
I knew,
Okay.
this plus, no.
He's saying pay, everybody else is saying not to pay, he's abstaining. There we go.
All
So
right.
now you got 4, 1, and 1.
I thought I counted that. I wasn't-
Well, I understand, but it,
weird how it's worded.
I don't know if you still got Eloise's vote, right?
Yeah.
Eloise, do you wanna pay the 14,000 or not?
No,
You do
I
not
got you
wanna pay
vote.
14,000?
no.
Okay,
And I got you both right.
okay, you're right then.
I don't wanna pay
Now we
it, but
got
I want to go to, mediation, if that's possible.
That was not motion. Motion is.
I don't know what it ended up, man. 4-1.
If she's not paying,
I don't want more debt.
It's 4-1.
I mean, I'm just.
But then if you don't want more debt.
I don't want no
then
more
you-
debt. So,
Then your vote should be.
we
yes.
vote for paying this, because if we go to
She's
law,
voting for paying this and not paying
Yes.
more.
Was that the way y'all understood that?
No.
Okay, so you're voting like Craig did.
But
Right,
yes,
right, Craig.
yes.
Do you understand? Then it is 3.
3-2.
I vote for pay, get it over with, be done.
Okay.
No, I want to go to mediation.
Anything else come before the board?
Nothing else, I'll make a motion to adjourn.
Have a second? Move and second. All in favor, say aye. Aye. All opposed?
That was exhausting.
It's tricky out there.
No, I didn't. Was it me? Was I?
No, it was, I knew we were gonna have issue with it.
You should have been a lawyer, Donna. You should have went to law school. You're a good lawyer.
Too bad.
I